Good evening, everyone, and welcome to the Town of Tewksbury Zoning Board of Appeals. And we'd like to call the meeting to order. And first on the agenda is approval of our meeting minutes, which we don't have any, so we're going to pass that one up. All right. Why don't we start with the PMW Land Trust for a variance under sections 5.3.1 E3 and 5.3.2 of the Tewksbury zoning bylaw for front and side yard setbacks and a special permit under section 8.1.1.c to alter a previously non-conforming structure in order to construct a 21 by 36 second floor addition. Filed, sorry, missed the line. Where am I? Under the exterior of the home and the exterior and roof of the garage as shown on plans filed with this board. Said property is located at 16 Water Street, Assessors Map 94, Lot 156, zoned residential. And this was continued from 4/6. Is anybody here to speak on that? Please come up. Name and address for the board, please.
Jackie Welch and 10R Grove Ave, Wilmington, Mass.
Okay, can you tell us a little bit about what you're doing, please?
Sure. So in the denial letter, the variance for the front yard setback, it's an existing non-conforming. So kind of goes to number 2, extending a non-conforming. If I have some photos, but the house has a second floor, and I just want to extend so that it's a normal height on the second floor, and it's all over the existing footprint. And none of, even though it doesn't meet the front yard setback, it's just going up this way and no changes to that front portico. And the third one is about the accessory structure. So it's an existing garage. And I want to put a new door, add new siding, put some windows on it, but it sits 2 feet from the property line, so I have to come to Board of Appeals.
So you're not moving it, you're not adding on to the garage, you're not doing anything else other than...
Siding, windows, doors.
Okay. And then the house, though, you wanted to make it a little bit taller, right?
A little taller on the existing footprint.
Going to rebuild the front porch to make it 3 feet wide?
No, we weren't going to touch it.
Because according to your denial letter, it says the proposed front porch, I'm assuming they mean front, is only 2.5 feet wide. Building code says it must be at least 3. That's what puts you in your 25-foot setback.
Where are you reading that?
The denial letter,
Yep. What?
first sentence, second sentence.
Talking about,
Am I reading the wrong one?
yeah.
Maybe I'm reading the wrong one.
Is this one?
I'm reading the wrong one.
Yeah,
My
okay.
mistake, sorry.
All right.
Did I?
Not mine.
I just used what was here.
Do you want to use mine? So nothing's changing, you're just updating the house and the garage. The footprint of the
Yeah.
house isn't changing, the footprint of the garage isn't changing, and it's just because it's non-conforming. It was already non-conforming.
It was already non-conforming and I'm extending it.
Do you have any questions, Rob? Do you have any questions? Okay.
Who are the voting members on this?
I was about to say, the voting members are going to be me, Joe, and Dan. Is there anything else you want to add to this? No? It being an open hearings, anybody have anything they want to say? Anybody want to come speak on this? No? Okay. Somebody want to close?
I'll make a motion to close the
Both-
hearing,
both
both parts of the
parts.
hearing.
Please?
Second.
All in favor?
Aye. I'd also like to make a motion to approve PMW Land Trust for a variance under section 5.3.1 E3 and 5.3.2 of the Tewksbury zoning bylaw for a front and side yard setbacks and a special, apologies. You got to do them one at a time for the special permit.
Correct.
I'd like to make a motion to approve PMW Land Trust for a variance under sections 5.3.1 E3 and 5.3.2 of the Tewksbury zoning bylaw for front and side yard setbacks to alter a previously non-conforming structure in order to construct a 21 by 36 second floor addition, update the exterior of the home and the exterior of the roof of the garage as shown on plans filed with this board. Said property is located at 16 Water Street, Assessor Map 94, Lot 156, zoned residential.
All,
Second.
all in favor?
Aye. I'd also like to make a motion to approve PMW Land Trust for a special permit under section 8.1.1.c to alter a previously non-conforming structure in order to construct a 21 by 36 second floor addition, update the exterior of the home and the exterior of the roof of the garage as shown on plans filed with this board. Said property is located at 16 Water Street, Assessors Map 94, Lot 156, zoned residential.
Second.
All in favor?
Aye.
Aye. Okay, you're all set. Thank you. I'm trying to think what one's going to be quicker. So I don't have to say here. Timothy and Matthew Penny. The second one is fine. Okay, next on the agenda, we'd like to have Timothy and Matthew Penny for variance under section 5.3.2 of the Tewksbury zoning bylaw for front yard setbacks to construct a 3 by 8.33 front porch, and for variance under section 5.3.1E, 2 and 3, for accessory structure within the front setbacks. Accessory structure located nearer than 10 feet of the principal building and less than 10 feet away from the side or rear lot. Line shown on plans filed with this board, said property is located at 60 Wamisit Road, Assessors Map 98, Lot 14, zoned residential. Name and
Tim,
address for the board.
Timothy Penny, 60 Wamset.
Matthew Penny, 60 Wamset Road.
Can you tell us a little bit about what you're trying to do, please?
So the current garage and back porch are kind of like starting to fall apart. So really, we just kind of want to update that and build on top of it 2 bedrooms with a bathroom. The pre-existing structures are the 2 sheds in the pool, actually. So when we went and applied for the permit, they just said, you're probably better off just getting it all like put under paper if we're going for it anyways. That's why those are in there.
Okay. Do you have any plans of what you plan to add on to the house?
I do, yeah.
You do? Is there anything that we can keep here?
Yeah.
Thank you. Here's my voting. The voting members on this one is Joe, Nancy, and Rob. So do you guys want to look at this with me? Yeah, right. Looks nice. So going from 19 to 24. Proposed is 26, that stays the same. That's a foot longer, 37 from 36. Rear elevation. 24. Existing is 40. This one. This one. Yeah. Yeah. Same. Garage. Timber and sunroof.
Basically on the house, right? Everything's good on the house except the front porch is gonna be too close to the frontage.
Right.
And then everything else is accessory structures. This is gonna be this shed. So it's right now. It's in the front now.
Okay, that makes sense.
That shed is too close to the property line. That deck is too close to that
Close to
property
that,
line.
the whole thing is
That's,
too close to it.
that's all the accessory structures.
That's all existing.
Brothers. Yeah,
Neither here nor there, but now that's why he's here with all this. That's why he added it.
How long ago did you buy this house?
What'd you say?
How long ago did you buy it? How long did you buy
About
it?
2 years ago, sorry.
2 years?
Yep.
You didn't build any of this stuff?
No.
No.
Are you taking out any of the sheds?
We would rather not, but
We may have to move, just move them for convenience for getting trucks in and out of there from that front yard area. But,
the back one, we'd rather leave.
yeah,
So the front one you're gonna move and put back?
yeah.
That's what you're thinking?
If it's
Right.
possible.
How big is that shed?
It's probably 10 by 10-ish. 10 by 5, something like that.
Just sitting on concrete block or something?
Yeah.
Yep.
I think it's cinder blocks, yeah.
How about the one in the back, same?
Same thing, yep.
In-ground or above-ground pool?
It's an in-ground pool.
With patio around it?
Yep.
That's just because this is bumped out now a little more closer to the road. Everything else is already here.
Because what it looks like on your denial letter, the only problem you're having with what you're building is your front setback.
Correct. So the porch is going to be the front porch there.
6 inches too close.
Exactly.
6 inches too close to
To the-
keep it the 3 foot.
So we're really just doing that for more curb appeal, so
Yeah.
it looks normal.
and everything else is nothing that you're changing, you're just trying to,
Get it all, so it's like legal and makes sense.
I don't have any other questions.
then, any question?
I'm good, I have no questions.
Okay, being a public hearing, does anybody have anything they want to talk on or anything? You do? Okay, please go to the podium, name and address, please.
Okay, my name is Drusilla Paldino, and I live at 43 Wamasett Road, across the street from
Okay,
the Pennies. Okay, so first of all, maybe you could explain, I already did talk to the building commissioner, but he didn't have the whole plot plan in front of him, so he couldn't give me some of the answers. But according to the information that I got from, Town Hall, the variance is against what exactly? Can you, beside the front porch?
that's really it.
Isn't it for the setback of the,
Well, what they're looking for is, with his construction, it's the front porch.
okay,
With existing, it's a variance from accessory structures. No accessory building or structure except a permitted sign or roadside stand shall be located within a required front yard setback. So that's the shed and the pool. Because the shed, the front shed and the pool are more towards the front of the house. So they're in the front yard setback. So they need a variance for that.
and what about the extension of the garage to put another story up?
That's fine.
That, yeah, they meet the
With two
guidelines.
bedrooms? Aren't they pushing that back, though?
No,
It's all the same,
not according to,
their plans.
you were adding 5 feet to it.
Correct.
Towards the pool.
Correct.
And it's going up, but it's 5 feet towards the pool, but he can do that. It's called by right. I don't like that term, but he's within his setbacks to do that.
Okay, well, I have a problem with the front porch then, because it'll be very close to the house, and there's no problem with the garage, correct, according to the variance?
Correct. According to the variance, it's going to be 24 and a half feet away from the street.
And it's supposed to be 25,
It's supposed to be 25.
so it doesn't follow code.
Correct.
Okay, well, then I have a problem with that also.
Okay.
Okay, and I can give you the reasons why. I mean, I wasn't able to get all the reports from the police department because the calls were on dispatch and it was gonna take them quite a while to get. But I do have one that they gave me about ongoing parking issues in the winter and whatnot. I mean, there's several cars there now. And, it's a 3-bedroom and they want to make it a 5-bedroom. And I do have a problem with that, living across the street, because the amount of cars, and I know they stated in their letter that they want to try to make it better for the neighborhood, but adding 2 more bedrooms, there's going to be more people there. There's been several complaints, and if you extend the meeting, I can get them from the police department, of ongoing parties there, starting on Thursday, Friday, Saturday, and Sunday. And look, everybody likes to have a party. I don't have anything against people having parties, but this is ongoing, okay? It's every weekend in the summer. It's very loud, speakers blaring, profound language. I mean, I can't sleep because I can hear it all from my house. And I'm an elderly senior citizen. I'm 72 years old. I fear to go outside with my dog because there's a lot of drinking going on there. And people are coming and going, they're whipping around the corner from Pie Wall onto Wamisit. I almost got taken out one night. There's just a lot of problems. And I just feel as, you know, respect for the neighborhood. I mean, I've been living there 30 years. We've never had a problem. Never. Okay, so it's a quiet neighborhood. There's other problems there, like they have an in-ground pool, fine. They have a fence that's half fallen down with slats missing. I fear a child could get in there. So there's a lot of issues that I think that need to be taken into consideration, since according to the letters that I read, it was denied.
Okay, thank you.
Okay?
Is there anyone else want to speak on behalf? Okay.
I'm Laura DiStefano. I live on 35 Brookfield. So we're actually back to back. Our yards abut.
What was the address again? I'm sorry.
35 Brookfield. So my question is regarding this patio and what they're calling a deck, which is right in view. I come out on my deck and their patio and deck is right in view of my land.
Excuse me. Can you pull that mic closer to you?
Sorry, now can you hear me?
I'm not even sure it's on.
Oh, I don't know.
Go ahead.
So, so the problem with that, and that is actually where all their parties are and all their fun stuff. So I have a problem with how close that's gonna be to my property. I can't have them any closer to me. My life is already miserable with them where they are. So how close would that deck and
I don't think that's changing.
patio be?
Nothing's changing on that. That's all staying the same. You got to address the board, you don't address the individual.
Those are gonna be getting demoed.
That's
So-
because what I read,
Those are existing and they will
Right,
be
those are
getting demoed.
existing, that's not even brought up here, that's not part of this, really. That's already there. They're not adding on to it. So that's, the deck wasn't, the back deck was not part of this.
any part of that. So they'll just go up. So how is this?
It's the front, really, that they're talking about in the garage,
Okay.
going
So
up.
this really won't affect me on my side? My
No,
side
ma'am.
is just his shed, right?
Right.
That's up against the fence?
Mm-hmm.
Okay. I just wanted to see exactly where I stood with all of this. I would prefer that the variances did not go through. It's your call.
Okay. Thank you. Is there anybody else that wants to speak? No? Okay, somebody want to make a motion? If you don't have any other questions?
I'll make a motion to close both lots on that.
All in favor?
Aye.
Aye.
So I think in fact, if there's problem with partying and parking and things like that, that
Yeah, that can
really
take
can't
a,
be our concern. That's more of a police matter.
right. Sadly, there's nothing we can do with the partying or any of that, so our main concern is just the variance.
The building commissioner is making them change the front porch.
Yep. Sure. It's not much bigger. From that to that. Aesthetically, it looks nicer. No. It's already there.
No.
This is what,
This means, yeah.
this is what we're doing. This is what we're doing. And then it's just, I think, going up on this, not adding on here or anything. So it's staying, same footprint.
I was trying to find something that showed the side of that porch. What is it now? Is it just a,
Yeah, it's just the stairs, it looks like.
so that's 2 feet out?
Yeah.
That's gonna be 3 feet out. Thing. You want that stuff?
Doesn't matter. We have other copies. We can
Yeah,
keep it.
well, I'll take that, actually.
We have a bunch of them. Yeah.
Keep it in your print, you can have that stuff.
Yeah, we just need the print. I have to give that to her. Okay,
All right. All set?
yeah,
I'd like to make a motion to approve the variance under section 5.3.2, R40 minimum. Hold on, let me find this month's agenda.
what this?
All right, I'd like to make a motion to approve a variance under section 5.3.2 of the Tewksbury zoning bylaw for front yard setbacks to construct a 3-foot by 8-foot, 8.33-foot front porch. And for a variance under section 5.3.1 E2 and 3 for accessory structures within the front setback, accessory structures located nearer than 10 feet of the principal building and less than 10 feet from any side or rear yard line. As shown on plans filed with this board, said property is located at 60 Wamset Road, assessors map 98, lot 14, zone residential.
Second?
Let me just make a comment before we vote on that. It seems like your neighbors are unhappy with the way you guys are acting over there.
Yep.
Don't make us regret this.
So,
Do the right thing over there, please.
yep.
Motion's been made and seconded.
All in favor?
Aye.
Aye. Good luck. Move your mic.
You're welcome.
Next on the agenda, I'd like to call up Denise Ferguson for a variance under section 5.3.1E3 of Tewksbury zoning bylaw for side yard setbacks to install a 15 by 30 above-ground pool as shown on plans filed with this board. Said property is located at 96 Maplewood Ave, Assessors Map 94, Lot 85, zoned residential. And the 3 voting members are Dan, Joe, and Rob. Okay, name and address for the board, please, and tell us a little bit about what you're doing.
Denise Ferguson, 96 Maplewood Ave.
Jeremy Bergeson, 96 Maplewood Ave. We are proposing to put in a 15 by 30 above-ground pool. It's going to be within the side setback. It's going to be 2 feet from the fence, so that's why we're requesting
Excuse me,
variance.
just,
Sorry.
thank you.
No worries.
Go ahead, continue, I'm sorry.
No worries.
It's okay. So we're just asking for the variance for the side setback because it's going to be within the 10 feet. It's going to be 2 feet from the property line, and if we put the pool any closer to the house, then we'd have to have a special variance because of safety issues. So
Okay.
that's why we're requesting this.
How close is it gonna be to the house? It's gonna blur it out there,
20 feet?
20 feet?
Is there a shed where the pool's gonna go now?
Excuse
Is there
me?
anything where the pool's gonna go right now?
That's where the proposed pool is going to be right now.
Yeah, well.
In your interactive property map, this is you here, right? Sorry.
It is. That was
That's
torn down.
not there.
That's not there?
That's not.
Yeah,
No photo?
yeah.
Thank you.
We had to go through a special permit. I think it was like 2016, we did the family suite for my parents. So it's gonna be, that's their deck right there, and the pool is 20 feet from their deck. Yeah.
And there's a fence there on that property line?
Yeah, it's our neighbors, is right next door, and we've spoken with them.
And they're okay.
They're okay with that. Yeah.
I think they're lost, I don't know where that paper is.
I have a copy, do you want it?
No, I haven't, I just
Okay.
didn't know yours was the binder, I apologize.
Yeah, I was trying to
I
make it.
appreciate the binder, I'm
Very
not
nice
gonna lie, I love the binder.
That was on me.
Very nice.
I watched one of your meetings and got feedback to make sure.
And that was the one comment I made was the binder. I love
Yes,
the
and I
binder.
love that. Because the last time I did this, I was pregnant with our last daughter, but we had a lawyer for that because that was so complicated.
I see you already bought the pool.
Huh?
Did you already buy the pool?
It's in our
boxes in the
boxes
driveway.
in the driveway.
Must have been surprised when you got denied the permit.
Huh?
You must have been surprised when they denied the permit.
No,
Actually, we were expecting it.
we understand how it works. Our neighbor across the street did the exact same thing, and he actually gave us
Information on how
he
to
gave
do
us
this.
his electrician and his plot planner. So we're doing exactly, yeah. It was nice to have neighborly support.
Yeah.
Yeah, because he asked it for the one side of his neighbor.
Mm-hmm.
We live in a great community, so.
I don't have any other questions.
Yep.
I'd like to make a motion to close.
I'm curious what the neighbors have to say, if anything.
Seeing it's an open hearing, is there anybody here who'd like to speak on this? No? Okay.
Motion to close both parts of the hearing?
Second?
Aye.
All in favor?
Aye.
Aye, okay.
I would like to make a motion to approve Denise Bergensen for a variance under section 5.3.1E3 of the Tewksbury zoning bylaw for side setbacks to install a 15 by 30 above-ground pool as shown on plans filed with this board. Said property is located at 96 Maplewood Ave, Assessor Map 94, Lot 85, zoned residential.
I'll second that motion.
All in favor?
Aye.
Okay, you're approved.
Congratulations.
Do you have
Thank
a
you very much.
question? How does it work with the electrical? Like, our electrician already pulled the permit, and now we just
We have to
need,
get the town.
You just need to work with the town, they'll have something.
The
what?
decision letter, right?
Yeah, you'll get a letter.
he just has to come out and examine it, I guess.
Yeah.
That's all but we couldn't do that until we got this. Is that how it works?
I think, I honestly don't know.
I think you get
I
30
think
days to
you-
dispute
yeah.
our decision when the neighbor's doing something,
Okay.
something like that.
So we got,
Call the office.
all right, so we guys are,
Thank you very much.
Thank you. Okay, next in line is Garrett and Louis. Can you? Baruch, thank you. For a special permit under section 8.1.1B of the town of Tewksbury bylaw to relocate an existing dwelling from an abutting lot as shown on plans filed with the said board. Said property is located at 1187 Main Street, Assessors Map 61, Lot 107, zoned Town Center. Okay. Good one. Okay, name and address for the board, please, and a little bit about what you're doing.
Great. Good evening, Madam Chair, members of the board. My name is Don Bornstein. I'm an attorney with the Office of Johnson and Bornstein. We're located at 12 Chestnut Street in Andover. I represent the Barabys and their various entities who are the applicants on this application. And with me tonight is Jim Hanley, the project engineer. Also, Garrett Barabee is right behind us right here.
Okay, great.
And I'll give you a brief description of why we're here. So the Barabys and their various entities own several different parcels on Main Street, just about half mile down the street from here. What we're trying to do is clean up a bunch of lot lines. We've got a collection of buildings, a collection of parcels. We're basically consolidating those into 2 complying lots under the fairly new town center bylaw to be in compliance with that. And also on that lot, it is the home to the McClellan oil delivery business. And so that business will be consolidated on one of the lots, and the second lot will be a complying lot under the town center zoning. We'd like to go in a little more detail for you. We brought a plan with us, and I'll hand it over to Jim, and he'll just explain to you what's on the plan. We've got one building that's moving and a couple buildings that we're proposing to raise, so he'll explain that for you in a little more detail.
Great. And the ones voting on this one will be myself, Dan, and Rob.
Okay,
Thank you.
great. So I'll just kind of walk through. So it's Jim Hanley with Civil Design Consultants. So essentially, we have 3 different lots. We have 1167 Main, which is, which one is it? It's this one here, existing. We have 1180, which has a single-family residence on it. It's about half an acre in size. We have 1177, again, there's a single-family residence on that, about a half an acre in size. And then we have 1187, which kind of does this unique kind of shape here. So it actually has frontage on Main Street here, wraps around these 2 single-family homes, and has frontage along here. And this one is about 2.1 acres in size. So the oil business is run out of this area right here, or this lot right here. And so the idea here is that we take 3 lots, we turn them into 2 compliant lots. Lot number, I guess we'll call it lot number 4, is 1 acre in size, and it has, I believe it's 122 feet of frontage. And that would parcel off the existing commercial use that we have here. And then to kind of clean this up, There's an existing building here that was at one point used as an office for this use, so it doesn't really make sense. It's not really connected to it. You got to go through backyards. Because they own, were involved in the ownership of all three, they were able to do that. But currently, it doesn't really make too much sense. So the idea here is that there's an existing single-family residence on the 1167 lot that has some architectural significance. It's been in the town, I think it was built in 1933, give or take. It's been there for a while. It's actually still in pretty good shape. The idea would be to take the original portion of this house and move it about 70 feet over into the new lot, which will give them some additional added office space at that location. Beyond that, the site has wetlands. It's got the local buffers associated with the wetlands. It has floodplain. There's a handful of things going on. But in essence, that's the general description of what we're trying to achieve tonight.
And the reason we're here for you tonight is we've got a special permit request under section 8.1.1B. You've got a letter from the building inspector explaining why that is. The oil business, of course, long pre-existing legal non-conforming use, but we're making some, either an alteration or an expansion to it. We've got a building that's moving. There'll be some office space located in there. So we believed we needed that finding from the board. The building inspector agreed with us. And before we bring our A&R plan accomplishing this cleanup of the lot lines and the buildings and making two sensible lots out of the sort of the hodgepodge of the parcels out there now, we wanted to make sure we had that special permit from this board to be able to do that.
So it's basically a special permit for the oil company.
Yes, yeah, I think you could think of it like that. I mean, we're making a bunch of changes to all those lot lines, but I believe the building inspector's finding was because we are repurposing a building in connection with the oil business use, that could be considered a change or an expansion of a pre-existing non-conforming use, and for that, we need a finding under 8.1.1B.
Well, B is use.
Yes. Yeah.
So the only use that's going to stay there is the oil company, correct?
Correct. And we believe both lots are fully complying under this plan. So I do, on the application, I have noted of requested relief under both B and C, just to be careful, catch it all. Our review of it was we didn't necessarily need that relief under C. I believe that was the building inspector's determination because his letter was written specifically to B, but we wanted to have that in front of the board on our application in case anyone disagreed with us when we showed up in front of you, that there was some dimensional issue with this. But I think our conclusion is dimensionally, we think we're okay. We wanted to give the board an opportunity to disagree with us if you did and have that on our application in case we needed that finding as well.
Well, if you're not dimensionally okay, you'll be back to us, right? Because you'll need variance. If you're not dimensionally okay.
Yeah, if it's that sort of thing, yeah.
I think I'm confusing the oil company's structure, and you said there was a house that was from 1933 that you're relocating?
Yes, yeah.
That house has nothing to do with the oil company, right?
Currently, no.
So in the variance, it's saying to relocate an existing dwelling from the abutting lot. They're speaking of the house, not the oil company. Is that a correct statement?
Correct, yeah.
So we're only looking for a special permit to move that dwelling, nothing else.
I believe with all the changes in the lot lines, that's the one that triggers the need for the special permit. I think you're right. I think that's what triggers the need for the special permit. I believe that's how the building inspector's letter writes it up, is because we're repurposing that existing house, which is a nice, very architecturally aesthetic house, something that probably should be preserved. The Barabys want to preserve it. They're going to move it off what I'll call the new lot, the one to the right on this plan. They're going to put it on the lot where their oil business is consolidated, and they'll repurpose that building for some additional office space, that sort of thing.
So when you move that dwelling, is it going to be within all the bylaws of the town once it's moved?
Setbacks, yes. Yep.
All?
Yep.
Yeah, we'll be dimensionally compliant on that structure, but because we have the oil business use occurring in it, the office space, that's what I think is triggering the need for the special permit we've asked you for.
So this here, this is currently how the lots are right now, right?
Yep.
Yep. And
Yeah, you can see it's a little bit of a crazy configuration.
Yeah.
They wrap around each other, and there's buildings sort of scattered about that site. It's just an artifact of just the way things were built and lots were laid out over time. So we're basically trying to modernize those lots, bring them into conformity with your town center bylaw. Excellent new bylaw. We're taking a look at that. And, but we do want to save that old home because we think it's a quality structure. It's a nice sort of feature on that section of Main Street. Give it a new purpose, new lease on life, and I think it'll work nicely with the oil business.
So if we go ahead and approve the special permit, when we approve the special permit, we're only going to be approving it to move that structure. Is that still going to meet the needs of all the other reconfiguration that you're talking about with the lots and the lot lines and stuff like that?
Yeah, I think that was our conclusion.
Yeah, I think so, because we'd still have to go through the A&R process to solidify the property lines.
Yeah, so the lot lines will
Right.
change through an ANR endorsed plan from the planning board, but we didn't want to do that without having the zoning all teed up correctly. And I think you're right, though, which is the only thing that triggers any need for zoning relief is that the structure being moved and repurposed in the oil business.
Because it's a non-conforming structure currently, and you're going to continue to move a non-conforming structure to the other side of the lot. That's what's triggering it, correct?
Yeah, I think actually it's non-conforming now, and we're actually just dimensionally, and we're going to make it dimensionally conforming. But the use of it in connection with the oil business, because the oil business use is non-conforming, I think that's what's triggering
Did you
it.
read the denial letter?
I did.
It's use, not particularly the structure.
Yeah. Yeah, and there were so many
The
moving,
building commissioner was looking for 8.1.1D, which is use,
Yeah.
which is the oil company. And this building is attached to that oil company. So they're looking to change, to modify an existing non-conforming use, which just means they're gonna take the building and use it. But it's not necessarily the building, it's the use of the building, because they're attaching it to the oil company. It's one of those good old-fashioned existing non-conformings.
Yep.
We just put
Fun
new
ones.
numbers on it. And then B, or, excuse me, C. C.
C is the non-conforming structures.
C is the non-conforming structures. They threw that on there just to cover all their bases, but the building commissioner isn't actually looking for that.
He's not. So we're just determining that when they make the change, it's not more detrimental to the existing non-conforming use for the neighborhood
To use,
to use.
and if we go with C, it's the structure.
But I don't see C anywhere.
It's on their application.
It is.
Yep.
And that one's just your typical, there's a non-conforming house and they want to rebuild it.
I don't have any further.
You know what?
Nothing. No, I don't have any questions.
I'm good.
Took me a while on the road to deep.
It being an open hearing, does anybody have anything they want to add? Say, no? Okay,
To make a motion to close both parts of the hearing?
somebody want to second that? Still going, sorry.
Are we done?
Thought you said you were.
Yeah, I'll second that.
All in favor?
Aye. I'd like to make a motion to approve Garrett and Louis Berube, apologies, for a special permit under section 8.1.1.b of the Tewksbury zoning bylaw to relocate an existing dwelling from the abutting lot as shown on plans filed with this board. Said property is located at 1187 Main Street, assessor map 61, lot 107, zoned town center.
I'll second that motion.
All in favor?
Aye.
Aye.
Congratulations. Great.
You're all set.
Thank you for your time.
Thank you.
Thank you very much.
All right, so. What's the other one?
We didn't proceed, but it was
So
on,
question
yeah.
on.
Denial letter.
Recommended.
Got it. That makes sense. Okay. All right. Last but not least, Margaret S. O'Brien, care of Johnson and Borenstein LLC under Mass General Laws, Chapter 48, Section 8, as a party aggrieved by a decision made by the building inspector in a letter dated December 9th, 2022, to construct a 40 by 60 single-family dwelling with a 30 by 60 garage. Said property is located at Foster Lane, Assessor's Map 24, Lot 26, zoned residential, and this was continued from 4/6. The voting members is Rob, myself, and Joe. Name and address, please, for the board, and a little bit about what you're doing.
Sure. Good evening again, Madam Chair, members of the board. My name is Don Bornstein. I'm an attorney with the Office of Johnson and Bornstein. Our office is located at 12 Chestnut Street in Andover. We're here with you tonight on, I believe, what is known as 0 Foster Lane. We're here in an appeal of the building inspector's denial of a building permit. And if you'd allow me, I'll just give you a little bit of history of how we ended up here. And it starts about a year ago. So back on April 14th of last year, 2022, I was working with Mr. O'Brien and his wife Margaret, and they own an approximately 3-acre lot off of Foster Lane, an unconstructed private way, which would eventually lead to access on Troll Road. And they were proposing to build a single-family house on that lot. Now, the lot is, of course, plenty large enough in lot area, although the frontage is slightly smaller than what's required today. But having some familiarity with the lot, I knew that it was a long pre-existing lot and would be subject to the zoning freeze, or sometimes called grandfathering protection, that's afforded to isolated residential lots. So I prepared an 88-page package for the building inspector, sent that to him with a letter back in April of last year, explaining the title history of this lot and the fact that it was subject to a zoning freeze and therefore should be considered a buildable lot. That was under consideration with the building department for some time. The building inspector requested some revisions to the plan to show a little bit more of the details of what was being proposed here. You can see on the plan I have up right now, the access comes in off of Foster Lane. You're only seeing a small segment of Foster Lane on this plan. It's a driveway that goes out towards the back of the lot. You've got a single-family home, a little bit of grading around that single-family home. We proposed a turnaround area for public safety vehicles on the lot, and we had shown some additional information that the building inspector had requested. Mr. O'Brien continued with his efforts to receive all the necessary approvals to build that single-family home. He applied for an order of conditions with the Tewksbury Conservation Commission. He was granted an order of conditions. There is a wetland crossing required to get into the building portion of the site. It's within the 5,000 square feet that's generally allowable for wetlands crossing. The town's Conservation Commission approved that order of conditions, and we have a good outstanding order of conditions for that lot now. Mr. O'Brien also sought an earth disturbance permit from the town's planning board. The planning board has also granted that earth disturbance permit. I will note for the board that it is under appeal by an abutter. I believe the abutter is here with us tonight. Following those additional approvals, Mr. O'Brien sought a building permit from the building inspector, and the building inspector initially denied the permit, citing the deficiency in the frontage. I pointed back out to the building inspector through a series of communications with him that he had this lengthy package which established that it was a grandfathered lot or subject to the isolated residential lot zoning freeze under Section 6 of the State Zoning Act. I did get a clarifying email that the concern actually that was causing the denial of the building permit was a claim of lack of access rights in the private way Foster Lane. Now, I'm not quite, we still have the denial which says it's for lack of frontage, but that package, that 88-page package, which I believe clearly establishes that the lot itself would be protected by the zoning freeze of Section 6 of the State Act. That's also in your materials. We filed that with the application. To the extent that that issue is still live at all in front of this board, I would direct you to that package as to the zoning status of the lot, and that it is that the zoning status is one of a grandfathered or lot subject to the zoning freeze. But that then still leaves us with this question of the access rights over Foster Lane that the building inspector has indicated he believes is still a live issue. He provided a copy of a 1994 appeals court case that was brought by Attorney Plunkett, I believe, who is also with us tonight in the audience. And the conclusions in that appeals court case is what the building inspector was citing to, I believe, for concerns about access rights over Foster Lane. So I'm going to get up quickly and just turn the page on the plan so we can talk a little bit more about Foster Lane. So let me just orient you to this fairly old plan that laid out this area with lots back in 1919. So here we have what is known as the Wamiset Villa Plan. It was produced by the J.W. Wilbur Company, which was actually a fairly large developer, parceler of land back in the early 1900s, still exists today, actually. And they had acquired this fairly large site and then laid it out in a bunch of little parcels. You've probably seen these types of plans before, often referred to as plat plans. Foster Lane on this plan is right here. I've darkened the lines a little bit around Foster Lane just so we can see a little bit better. The lot that we're talking about with Mr. O'Brien has historically been known as the twist lot. Twist lot here, I'm having a little trouble hearing you. Like I can hear you a little bit.
There's a microphone on the podium.
If you want to go to handheld mic too.
Yeah, on the podium.
Yep.
Sorry, I just.
Thank you.
No problem, it was hard to pick up.
Thank you. Thank you.
My son's a live sound engineer, so I appreciate that. All right. So I was saying the O'Brien lot has been historically known as the Twist Lot, 3 acres. You see it here. I've highlighted it in yellow so we can see it on the plan. What happened back in 1994 in the appeals court decision that was provided to the building inspector is Mr. O'Brien, back in that time, had looked to divide the Twist Lot into 2 parcels, had received a definitive subdivision approval from the Tewksbury Planning Board. So we got an approval for a 2-lot subdivision from the planning board. That was appealed by Mr. Plunkett and his clients at the time. One of the reasons they appealed it was they claimed that the Twist Lot did not have the benefit of an access right over Foster Lane. Mr. O'Brien was actually successful at the trial court. The trial court found that the O'Briens did have access over Foster Lane to access their lot. Attorney Plunkett appealed further to the Massachusetts Appeals Court. The Massachusetts Appeals Court found 2 things. And they found 2 things because O'Brien was arguing 2 things. So he claimed at that time, this is back in the mid-90s, that he had rights to access over Foster Lane for 2 reasons. One, because of adverse possession, and you're probably familiar with the concept of adverse possession. If you've used something for 20 years, you generally have the right to continue to use that. You either own it through adverse possession, or you've acquired the right to continue to do that thing like an easement through prescription. So he argued that by adverse use of Foster Lane, he had the right to do it. So that was his number 1 argument in that case. And his second argument was that by virtue of this plan by itself, that by the J.W. Wilbur Company recording this plan, showing the Twist Lot on it, that he was entitled to what's called an easement by estoppel over Foster Lane. So you had 2 different legal theories, adverse possession and easement by estoppel. The court looked at those arguments, heard arguments from Attorney Plunkett. Attorney Plunkett was successful. The appeals court said we don't find adverse possession because Mr. O'Brien didn't show a full 20 years. He only showed evidence of part of that 20 years, didn't show enough time to fill the full 20 years. And the court said that at this time, when J.W. Wilbur Company recorded this plan, they did not own the Twist Lot. They owned the other land shown on the plan, but they didn't own the Twist Lot. And because they didn't own the Twist Lot when they recorded the plan, the appeals court said, we can't find that there's access by virtue of an easement by estoppel, the second legal theory that they were arguing under. And that was the end of the case, 1994. Fast forward 20-something years, almost 30 years now, and here we are again. We're not talking about a subdivision anymore. We're talking about a single lot, single family home. And the O'Briens came to me to take another look at this. We had the benefit of the building inspector's advice and denial. And then I began to study the documents that are available in this case. And what I studied most of all was this plan. Because this plan is unusual, because if the J.W. Wilbur Company owned this land, and they owned these last 2 lots, but they didn't own the Twist Lot, the question that I asked myself was, when they laid out Foster Lane, the first time Foster Lane appears is on this plan. This is where Foster Lane was born, was on this plan, and along with the rest of these ways. Why did they run Foster Lane all the way to the Twist Lot? In fact, not even just to the front corner of the Twist Lot, all the way to the back corner of the Twist Lot. If they wanted to be able to sell off parcels with ways to provide access to the parcels they were selling, all they had to do was stop it right here. They could have ended Foster Lane right here, provided access to all these little parcels along the lane, and then from the end of it, these folks here, these last lots that are called A and B, they would have had access off the end. Why did they run it this distance? Especially, why did they run it this distance along what is now the frontage of the Twist Lot, now the O'Brien Lot? And so I wanted to answer that question for myself. So I dug back into the title of this property and the title of the J.W. Wilbur property to try and understand why these folks, J.W. Wilbur, sophisticated developer and land speculator at that time, again, continues to be such today, why would they have done that? They must have had a reason. And what I believe that reason was, and it's in the packages and additional materials I've filed with the board, And I have a handout for you tonight. I'd like to give that to you now. Hold on. And this is a more condensed version of what the results of our study was on Foster Lane.
Thank you.
Thank you.
So what we did that I don't believe was done back in '94, when the appeals court considered this, and it's no knock on the appeals court, and it's no knock on Attorney Plunkett. Mr. O'Brien's attorney at the time argued two theories. That's all that was considered. We have the appeals court decision. Those are the only two theories of access over Foster Lane that were considered. And again, there was access by right of this 1919 plan, or there was access by right of 20 years of use. The appeals court disagreed with both of those. What I did is I went behind this plan, so I went earlier. So I hired a couple title examiners and asked them to trace the title of the J.W. Wilbur property, which then became Mr. Plunkett's attorney's property, at least a piece of it. And I asked them to go back in time on that lot. And this is some of what they found. So what they found, and you see in front of you now, is a compilation of 7 deeds. So these are the chain of title that starts with the deed into the J.W. Wilbur Company. So I've listed them most recent to oldest on this list right now. So number 1 is the most recent. That's when the J.W. Wilbur Company picked up the larger parcel, including the area that was eventually included within Foster Lane. And what we found in each of those 7 deeds, and we've brought them back as far as 1850 right now, is in each of those deeds they have this interesting language that I think is key to the puzzle here, which is it includes the statement, reserving, however, the rights of passageway through and over the premises above described to which the same are now subject. 1800s deed language. Lawyers are difficult to understand today. They weren't any better back in 1850. But I think it's clear what that language means is that this land, including the land that became Foster Lane, was already subject to passageway rights before this plan ever existed. Before Foster Lane ever existed by virtue of this plan, this land was already burdened with the right of passageway. And we know that by this language here that says it's reserving the right of passageway and that right is something the land is currently subject to. Now, the land that it's describing is this land, the J.W. Wilbur land. I've also included all the deeds. I believe they're all handwritten, of course. We've highlighted the sections that we think are most critical, not expecting the board to try and digest all that handwritten language tonight. But that statement appears in each of those deeds going back to 1850. So what I believe that means is the reason, and the question I asked from the start is, why did J.W. Wilbur extend this road all the way out to the twist lot? And the reason is because the twist lot already enjoyed a right of passage over this land. So when J.W. Wilbur got this property, that right of passage, it wasn't identified in a specific location. It was cited as existing. J.W. Wilbur needed to put it someplace because they wanted to sell all these lots free of that right of passageway. So what they did is they put it someplace. They put it in in Foster Lane. And they put it in Foster Lane because the rights of the twist lot to use this land to get out to Troll Road already predated this plan. J.W. Wilbur had a problem. They solved it with Foster Lane and extended it all the way out to the far end of Twist, so Twist wouldn't be able to complain that their rights of passageway had been denied to them by J.W. Wilbur. So they created this plan to do that. And I don't think that question or those facts were considered by the appeals court. And so that's why I think the 1994 appeals court decision that I believe the building inspector has based his denial on is not controlling here, and that the O'Briens do have a right of access. And that if they have a right of access, then that lot is a buildable lot subject to all the usual requirements, building code requirements, that sort of regular thing. But where the narrow issue, I believe that was before the board, is this lot sufficient that the building inspector could issue a building permit if all the regular requirements were met? And I believe the various materials I've submitted with the board establish that. I have Mr. O'Brien here with us. He's available to talk about specifics on his proposal for the property, what he wants to do out there, the type of home he wants to build, the way he's bringing in the driveway. I've explained to you the other approvals he already has. He's available to answer any of those questions. I don't know that they're specifically germane to the fairly narrow and kind of dense legal issue in front of the board tonight. But we're happy to answer any of those questions, and I'm happy to respond to anything you might want to ask me about some handwritten 1800s deeds.
When did Mr. O'Brien obtain the lot here?
86?
85.
1985.
Is Foster Lane, is that paved all the way up to the twist lot?
Can you say that one more time?
Is it paved?
No, this road is not constructed presently. I think, Kevin, you probably have some photographs or something, or some plans that'll show us a little bit more about just the practical situation out on the ground.
Is that Foster Lane owned by the town right now?
It's an interesting question. So neighboring this property, abutting the twist lot, now the O'Brien lot, that's here, there's been a small subdivision, cul-de-sac, that was constructed here, the Robbie Terrace Way? Is that how you say it, Kevin? Robbie Terrace Way, small subdivision. This was an open space subdivision. So the town, I believe, holds title to the back portion and actually a strip of land that runs all along Foster Lane. Do we have something that shows that? So here is that subdivision plan. So just to orient you, Foster Lane, the O'Brien property, at least one side of it here, Robbie Terrace Way, which is a newer subdivision road.
Thank you.
The town has this parcel to the rear as open space, because this was done assumedly as an open space subdivision. So this private developer granted this land to the town, and that includes this back piece plus a strip that runs all along Foster Lane out to its intersection with Poland Avenue. So the town owns this narrow neck and then this whole piece. I believe the consequences of that conveyance is that the town, at a minimum, owns to the center of Foster Lane.
Who owns the other half of Foster Lane?
That's a good question. I believe the person who would claim that ownership is in the room with us tonight, is Mr. Plunkett's current client, not the client that he had in 1994 for the appeals court case, but the current client, and I'll point him out again. Mr. Plunkett's here. I know he's going to want to address you. And I believe his client owns this side of Foster Lane.
To the middle of the road, or to the middle of the lane?
I believe that's likely the case. I'm not giving a legal opinion on that. Today, I haven't examined the town's title to the same extent I've examined the issue regarding access rights over Foster Lane. But I think that's a pretty fair assumption at this point, is that the town may own to the center line of Foster Lane, and Mr. Plunkett's client may own to the center line from the other side. In that situation, again, by virtue of the same issue considered by the appeals court back in the mid-90s, generally if you're conveyed land on a plan, and that land that you're conveyed on the plan abuts a way, then you generally get the right to use the way, and you generally own to the middle of the way unless the deed says something specific otherwise. So that's the general rule in Massachusetts, that if you're deeded land on a plan and that land abuts a way, you get the right to use the way and you own to the middle unless in the deed it says something different.
On that print, the parcel under your highlighted one and the one directly across from it, what goes on with those? Somebody else owns them and they're just sitting there?
So this, and I'll see if I can kind of line them up. So Poland Ave, called Martin Road on this plan. This Robbie Terrace Way, which is a small subdivision, is here. And the town-owned land, I believe it's all of Lot A and some of these little strips.
Okay.
On the far side, I believe this is Mr. Plunkett's client,
Right.
Mr. Nardella. Am I saying that right? Nardella? Is Mr. And through an entity. And his land, I believe, goes from this way here, along Foster Lane, actually wraps up around the twist lot, comes up here too. Yet in the back, it gets pretty wet, you got a little stream back here into the marsh. But you'll see this, the twist lot, is actually completely defined in this plan. It actually notes that there's a bound in there at the corner. A little unusual to show a lot, someone else's land on your plan to this level of detail. That also raised my eyebrows, which is why did they show in a butter's land with that level of detail? Includes distances, includes locations of bounds. They fully surveyed the twist lot to do that back then. Why did they do that? I think they did that because they knew they owed the twist lot something. They owed the twist lot a right of passageway. Because the attorneys back in 1919 were just as bright, if not brighter, in conveying land than attorneys today. And they had seen the same deeds that I have provided to you, and they knew they had a problem. They knew they had to do something about it. So they laid out Foster Lane to cure that problem.
Thank you. I haven't found it yet.
Did you find the denial from the original paperwork?
I think that was right here. But I didn't see it. I didn't see it one time, I can't find it now.
Found it.
Is there anything else you wanted to add?
Madam Chair, I'll just note for the record that I think you do have in your file, but I'll just note it for our recording tonight. I believe you have in your file my package to the building inspector dated April 14th, 2022. That's the 88-page package regarding the grandfather zoning freeze status. I believe you also have in your file my letter dated February 16th, 2023, which was after the filing of this application, and it was specifically responding to the issue regarding the rights of Foster Lane that I've just spent so much time explaining. So I think you have those two packages. They both have a bunch of attachments from me. I just want to note, I think both those things, in addition to our application materials, are in your file.
Yes, thank you.
I read that.
Yeah. Before. Yeah. Just that.
Read the whole thing. So if you remember when you were here a couple of months ago, we asked for advice from town council. And their advice back to us was, I'll read it to you, you probably have this anyways. There are 2 items to consider for public hearing regarding Foster Lane party aggrieved application. The issue regarding whether Mr. O'Brien has the right to pass or repass over Foster Lane to access the parcel he owns, map 24, lot 26, is not the subject of this application or for this board to render a determination. This issue is whether the findings of the Massachusetts Appeals Court case supersedes any subsequent title research is not the responsibility of this board. Okay? If the board chooses to make a finding on the applicant's assertion of protection under Mass General Law, Chapter 48, Section 6, is appropriate, and in doing so, overturn the building commissioner's December 9, 2022 ruling, the board may want to add the following exception to the decision. So that means your denial letter dated December 9, 2022 was for a variance under section 5.3.2 residential district, R40 minimum frontage. That was the denial letter. So if you come as a party aggrieved, this is our determination of this. As you come as a party aggrieved, what you're asking for is for us to overturn minimum frontage. Not who owns the property, not whether you have the right to use it, not who owns Foster Way, Foster Lane, just as a party aggrieved. And that's as directed to us by town council. And furthermore, we should also add in any decision that we make that this board makes no finding concerning the disputed access to the parcel by way of the land known as Foster Lane. That's from our town council.
And what is the date on that?
April 27, 2023.
Is that today? That's today. All right, I've not seen that
And
letter.
I have one, because we were supposed to meet last month, I have one dated April 6, 2023.
Is that what these extras are for? Should I hand them out?
What's that?
Should I hand them out?
Is that what?
They're
should we
extras.
say?
Yeah, you have
They're
extras?
all
Yeah,
on the table.
go ahead. Thank you.
So I have been in communication with town council. That had not been communicated to me before hearing it tonight. I do want to note that I do have 2 communications from the building inspector as well. And after receiving his denial letter, I raised it. I asked him to reconsider that position, because he didn't mention my letter from April of last year, or the 88-page package that I put together. And so the response I got back was, and here's one of the responses. It's email dated December 27th, 2022. The letter, and this is from the building inspector to me, the letter states that there is no frontage on a public way, parentheses, public way is the issue, end of parentheses. Please see the attachments. And then the attachments are the appeals court case. So rights over Foster Lane. And then subsequent to my filing, I got a further message. And this one says, and again from the building commissioner to me, it says, Attorney Bornstein, it has come to my attention that an application to the Zoning Board of Appeals as a party aggrieved has been filed. This was for hearing on January 26th. That would have been the first session we were teed up for. I wanted to alert you that even if the application is successful in finding that the lot is protected by a zoning freeze under MGL 48 Section 6, the grandfather and zoning freeze statute, I will still be required to deny the building permit application based on the attached judgment. Again, this is the second time referring back to the appeals court case.
I was just reading that in this packet somewhere.
Yeah. And then it says, if there are documents that's overturned or otherwise supersede, please forward them, which that's what I've done with the February package that I sent to this board and elsewhere.
Right, well, again, I go back to the letter we got from our town council.
Excuse me, this isn't from your
Today's.
town council, though, what we have. This is from your planning director, or your planning department.
Right, but it's from our town council. It's because the first, not last month, but the month before, when we continued, is because we wanted advice from town council.
Correct.
So this is the advice from town council.
Do we have a letter from town council or something over his
I have
signature?
not seen a letter from town council, I've seen this.
Again, nowhere on that letter or that email does it say, this is the recommendations of town council.
The April 6th one references for guidance of town council in the first sentence.
I couldn't hear you. What was that?
The April 6th Foster Lane party aggrieved application, the memo for the zoning board references council in the first sentence, per guidance of town council.
That's not the copy they have now.
No, it's not the problem. This is first sentence.
Thank you.
She just missed this.
Mm-hmm.
So I'll just note I wasn't privy to the April 6th memo either.
Okay.
And I was in communication with town council at that time.
Do you want to push this out?
I would
Yeah,
I don't feel comfortable making a decision on it.
I don't want to make a decision on it either, because I want to do what's right, and I say we push this out another month.
If we make a decision, we're gonna push them back another 20 years.
Yeah.
And if I had known these memos were out there, I might not have thrilled you with my expose on mid-1800s handwritten deeds.
That's okay, I actually enjoyed it, honestly.
And I do know.
It's interesting.
Again, although I know Attorney Plunkett is here tonight, he's sat through my lengthy expose as well. I'm sure he has something to say to the board. I did not necessarily expect the board to be making a decision on this tonight. I was expecting to see, eventually an analysis from town council. Clearly some dense legal issues involved
So we
here.
can ask for more advice from town council,
Yep.
see if anything's changed in 3 months. But right now, they're directing us not to make a decision on
Whether or not you can use.
whether you can use it or not.
I think the import of these memos is that we would then come back to you next month and ask that same question.
Then we can make a determination as a party aggrieved to whether we can give you a variance for frontage. Because that's what our denial letter states, is that you have 120 feet of frontage, you need 150. There's actually a couple more, you don't have enough. There's more on the application. You don't have the square footage either. But the denial letter specifically calls out frontage.
Yeah, and all that would be related to the Section 6 zoning free status. They all fall under
Right.
the same issue, yeah, so. So I would certainly be interested to hear directly from town council, myself, if the board's interested as well. Of course, it's your council, not mine, but.
So we want to make a motion to have town council weigh in again, right? And I'd also like to make a motion, someone to make a motion to push this off till next month's meeting.
Do you want to open it to the public?
Yeah, I'm going to open up to the public, yep.
I was going to say, you've got another good-looking guy in a gray
I
suit
know,
here that I
I
know
know.
would like to earn his keep.
Okay. I'd like to open it up. Does anybody have anything they want to say? Name and address, please, for the board. Oh, where's the mic? You got it? Great.
Thank you, Madam Chair, members of the board. For the record, David Plunkett. I'm representing JDB Realty Trust, the direct abutter to the property. I'm a resident of the town of Tewksbury, residing at 257 Fifth Street in the town of Tewksbury. Madam Chair, if I could just be certain, I had submitted a report on March 23rd. I just want to see, make certain that you have that in your package.
It's in there, yes.
Okay, you do, okay.
I did read that.
And basically,
Thank you.
a few things. First off, in my letter, I set forth the issues pertaining to that appeals court case. The appeals court case, there was a reference to that an affirmative decision was made at the Superior Court. As I pointed out in my cover letter, the appeals court made a statement that the Superior Court was clearly erroneous. In decisions by appeals courts, that's a slap on the wrist of the judge, that the court is saying, you shouldn't have done this. This was clearly erroneous. You don't usually see that type of language. The bottom line is the determination by the appeals court was after a number of years of litigation. This was not just something that people went in on a whim and the court issued the determination. This was years of litigation. The submittal in behalf of the applicant tonight relative to the so-called rights of access, as I set forth in my memorandum, that actually supports our position. Because in fact, the line of deeds which has been submitted to the board are all relative to the chain coming from the Wilbur parcel. And what was left out was going back through the twist lot parcel, that what I've submitted is, here are the deeds going back to when the Twists owned it in 1894. There's no reference to a right-of-way over adjoining property. There's no reference to any right-of-way there. So again, the determination by the court was that the right of access does not accrue to the owner of that twist lot because they're strangers to the land. They cannot gain under Massachusetts law any rights over land to which you are a stranger. So the fact that the Wilbur lot, the chain between that parcel and other adjoining parcel that was once part of the mother lot, doesn't confer any interest on the adjoining lot. And that's the determination of the court. The court was clear. So this is nothing that sheds any light. And this is a court determination that's been in existence since 1994. You can't just come forward and say, oh, you know what, I think that the court didn't know what they were doing. I think that back in 1919 that the Wilbur Company intended this to be an access to the twist lot. There's nothing in the record to indicate that. And the court found nothing in the record to indicate that. And to come back 28 years after the court determination and say, oh, let's just forget all that litigation that took place. Let's just forget the determination of the appeals court and say, yeah, he has access to Foster Lane. Bottom line, Twist Lot has no access to Foster Lane. Under our bylaw, frontage of a lot, it says specifically in our bylaw that it has to have the lot line, talking about lot frontage, the lot line coinciding with the sideline of a street, which provides both legal rights of vehicular access and physical vehicular access to the lot. The determination by the appeals court was, you don't have any access. You're a stranger to that parcel. Zero. Nothing. No rights. Under our bylaw, you can't say that he has frontage because it doesn't conform with the language of our bylaw. The issue in terms of, there was a reference to the land disturbance permit, saying that the planning board had issued a land disturbance permit. They didn't issue a land disturbance permit over Foster Lane because Mr. O'Brien, in order to get an affirmative vote, withdrew Foster Lane from the planning board's determination. And that's why we now have that under appeal, because the clear language of the open space development permit says that the site, you have to get a permit for the site to be disturbed. And this is clearly, from all the plans submitted, part of that site. And they said, oh, well, I'll take that out. Well, and then they went in afterwards and leveled it off. Even though the town had said, oh, you need a land disturbance permit. Filed it, saw that they were having problems, withdrew that parcel from it, and then went and leveled it. So we're dealing with a situation, people are making up their own rules. And it's wrong. It's wrong. We're in opposition to the board overturning the determination of the building commissioner, and we would request that the board uphold the determination of the building commissioner that this is not a buildable lot.
Thank you. Is there anybody else that want to say anything? No? Okay,
Maybe we could request town council to tell us exactly, like on their letterhead,
right.
what our role should be in this, if any. So I'd like to see us continue this to our May hearing.
Yes, I would too. So, somebody want to close both parts of the hearing first? No, we're going to keep it open. That's right. I'd like to make a motion then, request that this, what?
I'd like to make a motion. to
You make
continue.
it, go.
I'd like to make a motion
Sorry.
for,
Sorry.
it's not a motion.
It's not,
We just
it's a
ask town
request, right?
council- We request town council for more information on what we can and cannot do here as a board.
Mm-hmm.
And I'd like to make a motion to continue to our next regularly scheduled hearing
On town council letterhead.
on town council letterhead. Yeah. Make a motion to to continue to our next regularly scheduled hearing, which is May 25th, 2023 at 6:30 PM.
Second?
All in favor?
Aye.
Okay,
To be continued.
next month.
All right, thank you for your time and your
Thank
rapt
you.
attention.
Thank you.
Great.
Okay, next on the agenda, next meeting would be May 25th, 2023. We have no old or new business, so somebody want to make a motion?
Make a motion to adjourn.
Second?
All in favor?
Aye.
Aye.